Meeting is called to order. Public notice of this meeting was properly posted at the South Carolina Board of South Carolina Board of Speech Language Pathology and Audiology. Synergy Business Park, Kings Tree Building, 110 Centerview Drive, Columbia, South Carolina, 29211. And provided to all requesting persons, organizations, and news media in compliance with Section 30-4-80 of the South Carolina Freedom of Information Act. Members of the public who wish to view the meeting via live stream access are reminded to go to the website that's provided on the board's link that's provided on the board's agenda, excuse me. First item on the agenda is approval of the agenda, but before we do that, I want to thank the staff and the board members for your contribution for the last year and your participation in all of the heavy lifting that we had to do last year. Thank you for that, and we look forward to a very productive 2020. So the first item then is the approval of the agenda. Do I hear a motion, please?
A motion to approve the agenda for today's meeting.
Moved and properly seconded that the agenda be approved. All in favor, let it be known by saying aye.
Aye.
Opposes, nay. The ayes have it and the motion is carried. The next item is the approval or disapproval of absent members. I view everyone is present. Mr. Administrator?
Yes, Madam Chair.
Okay. Thank you very much. The next item is the approval of the October 16, 2025 meeting minutes, and you were provided a printed copy of the minutes. If you've had a chance to look over the minutes, our advice council made some edits. Opportunity to observe, I'll now entertain a motion to approve the minutes for that meeting.
Approve the minutes from our October 2025 meeting.
Second.
Second, that the minutes for the October 16, 2025 be approved. All in favor, let it be known by saying aye.
Aye.
Opposes, nay. Next item on the agenda is the administrative reports, and we will begin with the OIE.
Good morning. My name is Yarixa Alexander. I am the lead investigator for the Speech Language Pathology and Audiology Board. And the first report is going to be for information only. It is the OIE status report. This data was collected from January 1st, 2026 until January 7th, 2026. During that short period, we have not received any complaints. We currently have 3 active investigations, and we haven't closed any cases. Yes, ma'am. The second report.
IRC, please.
Yes, ma'am. So the IRC met, and they recommended 3 cases for formal complaint.
Can I ask a question for clarification? I think the copy that I most recently saw, no, excuse me, bad memory, excuse me.
Cases for active investigation, we need a motion to accept or reject the recommendation from IRC, please.
I motion to accept the recommendation from IRC.
Second.
Second, that we accept the recommendation from IRC. for the, all in favor, let it be known by saying aye.
Aye.
Opposes, nay. Ayes have it, and the motion is carried. ODC, Office of Disciplinary Counsel.
Good morning, Leanna McMenamin for ODC. As of January 5th, we have 5 cases open. None of those are pending hearings and agreements yet, and we have closed 1 case since January of 2025.
Next item is 5C, Financial Report. Mr. Williams.
Yes, Madam Chair, members of the board, you have your financial report before you. The board's beginning cash balance, which would have been of July 1 of 2025, is $2,638,563.28. The board's revenue since that time period is $48,150. The board's direct expenses are $83,637.26. The board's shared expenses are $49,962.21, with a current balance of $2,553,113.81. The budget is in good shape at this time, Madam Chair.
Accept your report as information. Ethics Commission.
Yes, Madam Chair, this time of the year to file with the Ethics Commission again. Jonathan should have already emailed you your travel document from last year. You're going to need that travel document to file with the State Ethics Commission. The filing is online, so you need to go to their website. He should have provided you the website in the email that was sent to you. If you have any questions about filing, you have to contact the Ethics Commission directly with any questions. The filing date is March 30th by noon. So you have to make sure you file by March 30th by noon. And if you fail to file by that time period, you could be penalized $100 per day. So we want to make sure you get that.
Much. Okay. Next item on the agenda is the application hearing, item number 6.
Okay. Ms. Lauren Schlagenhoff, and
Before we begin, would you give me the correct pronunciation of your last name, please?
Schlagenhoff?
Schlagenhoff.
Yes.
All right. This hearing is called to order. This is the matter of Lauren Schlagenhoff. The purpose of this hearing is to determine whether Ms. Schlagenhoff's application for licensure as an audiologist should be granted. Everyone is reminded that these proceedings are being recorded and that all witnesses must be sworn before they testify. All remarks should be directed to the chairman. My name is Dr. Gwendolyn Wilson, and I'm chair of the South Carolina Board of Examiners in Speech, Language Pathology, and Audiology. The attorney assigned to advise us during this hearing is Brandy Duncan, Office of Advice Counsel with LLR. A quorum of the board is present. Do any of the board members have any reason to recuse themselves from this matter? Hearing none. This hearing will be held in accordance with the provisions of the South Carolina Administrative Procedures Act and the statutes and regulations of the South Carolina Board of Examiners in Speech Language Pathology and Audiology Practice Act. Mr. Williams, have the board members received Ms. Schlagenhoff's application?
Yes, ma'am.
Did the staff subpoena any other persons to be here today to answer any questions we might have?
No, Madam Chair.
And what questions did the staff have concerning this application?
Yes, Ms. Schlagenhoff reapplied for the audiology license on October 28th of this year, October 28th of last year, and according to the record, Ms. Schlagenhoff initially applied for a license in May of 2021 and did not complete the process due to not having a passing score on her practice exam. Before in 2021, practice required audiologists to meet a minimum score of 170, and Ms. Schlagenhoff scored a 168 during that time period. Ms. Schlagenhoff has also been out of practice, been out of the profession since, or about 2018, so she's here to address the board concerning those issues on today.
Applicant is present.
Yes.
Are you represented by counsel?
I'm representing myself.
You understand that you have the right to be represented by counsel of your own choosing in this matter?
I do. I understand.
You're electing to waive that right and represent yourself instead, is that correct?
Yes.
Okay. Ms. Schlagenhoff, do you have witnesses that you intend to call to testify on your behalf?
No. No, ma'am. Thank you.
Schlagenhoff, it's my understanding that you received less than 30 days' notice of this hearing,
Yes.
but you are willing to waive that notice requirement and proceed with the hearing today. Is my understanding correct?
Yes, correct.
Okay. Okay, are you ready to show us why you should be granted a license despite the concerns raised by the staff?
Yes.
You may begin.
Okay. So I first wanted to say thank you for allowing me the opportunity to address the board today. I appreciate your time and consideration. My interest in audiology began when I was in college. I witnessed firsthand the impact hearing care have on the quality of life. A patient came in seeking hearing aids while caring for her husband who was terminally ill, and seeing how hearing allowed her to better connect during such a critical time confirmed my desire to pursue the profession and have grandparents who have hearing aids, so I just connected with people who needed a voice and needed to hear. So I went to earn my doctorate in audiology at University of Arkansas for Medical Sciences. I was very driven and dedicated to audiology, and my research won a national award at the Eddy Convention, and my work was published. Following graduation, I began working towards license and taking the praxis examination. I initially scored 168, which at that time was just below the passing score. Shortly after, COVID pandemic occurred, significantly disrupting testing opportunities, license process, and employment opportunities. During that period, I was required to financially support myself. Since we could not obtain a license, I started a cleaning business in Charleston, South Carolina. Later, I learned that the practice scoring had been lowered and that my prior score exceeded the current requirement. Based on that information, I applied for licensure in South Carolina in good faith, believing that I met the examination requirements since the score was lowered. Starting May 2nd, 2021, I was in contact with LR about my situation and was told to apply, and I did. Despite guidance and reassurance I was going to get my license, I was advised that at that time they just told me I needed to retake the examination. However, when at the time, students now, they only need a 162. So my whole point is, so now new students can graduate and score a 162 when I already have the knowledge of 168. And so in August of 2021, ASHA emailed me, because I had been back and forth with ASHA about this, and they suggested me to reach out to the state, and because I'd already scored a 168. It was difficult to reconcile in my mind that students and people can now score 162 while I already have a score of 168. As a result, I focused my efforts on sustaining my business. However, my desires to practice Audiology has never changed. I recently contacted the board on October 22nd, 2025, and spoke with Jonathan Owens, and that conversation encouraged me to, reapply and maybe be considered for licensure. I understand the board's concerns regarding the length of time I've been out of practice. I want to be very clear that I'm fully willing to complete refresher courses, supervision, continuing education, and keep in mind all this time I've been studying to retake it, because at that time they're like, oh, well, you already scored the score, just retake it. You already have the knowledge. But, it's been a while, it's COVID, and so I've been studying a lot. Right now my grandfather has hearing aids, so anytime I see a person who has hearing loss, I'm always trying to help them, and that's the way I can help since I don't have my license right now. My goal is not to my goal is conformant standards, but to meet them, I want to meet the standards responsibly. I respectfully request consideration of licensure with conditions of structured reentry plan rather than denial or prolonged prohibition or reapplication. Because I know I was told after this it'd be a whole year before I could reapply, and I could think before in 2021 I was never told that I had a whole year. My motivation has always been to improve quality of life, hearing healthcare, and remain committed to practicing audiology ethically, competently, and under the board's guidance and approval. I just hope everyone hears what I have to say. And I know there's other people who are struggling with the exact same thing I am. So I hope everyone hears me. So, any questions?
Much. Any questions now from board members?
This is Dr. Jason Wigan. Do you currently have employment opportunities lined up for audiology?
I know I have, where I live, there's a couple opportunities. And I know, when I was applying before, there's well, we can't talk to you until you get your license. So that's kind of my hold up right now.
And then, this is Beth Montgomery, I'm a speech pathologist. Were you ever licensed in any other state as an audiologist?
So in Texas, I was just still, you have a student license, and that's what I was operating then. But I've never been licensed in North Carolina or any other state. So no.
And then what about with ASHA? Were you able to complete that with them, or no, because you weren't able to start working?
So that's a good question. So with ASHA, they have different requirements as if you haven't taken the praxis in 5 years. Even if you passed, you have to take it again. So I'm not trying to do ASHA's requirements. And so, I know that's ASHA's rules, but that's why they told me to reach out to the state, because they heard what I was saying. And so I know everyone has rules, and I know this, as far as I know, South Carolina doesn't make someone retake it, even if you pass it every 5 years. Or if you're trying to apply and it's been over a certain amount of time, you have to take the test again.
So, this is Jason Wigan again. Do you currently hold your Cs with ASHA, or have, again, licensure, certification, different things you can have? Have you ever had those kind of certification or any kind of?
No, I never applied for my Cs, because they had more requirements and I didn't make them. So
Have you been able to maintain just some sort of continuing education, any kind of CEUs? You don't have license, but has there been any kind of effort on your part to stay?
yeah, so audiology online and courses online, that's what I've been doing to stay.
Have that saved somewhere?
I'll have to look up my courses I've completed, but I can get what I know I have. And like I said, besides like study material for studying for the test and all my books I've bought to help pass the test. I'm not sure. Multiple times, more than 5, maybe 6, 7, 8 times.
And you never got above the 168?
Correct.
Okay. And Dr. Wiggin can correct me on this. The scores were synchronous. And a debate about the audiology scores being one thing and the speechology scores being something else. So the interpretation that it was lowered, I'm saying it's probably not correct. It was reevaluated and reset so that the scores would be the same. Difficulty, I'm not talking about that. I'm just talking about the score, the pass number.
Yes, yes.
Okay.
Yes, so now it's 162, and not before the past score was 168.
Right, you said that you think you've taken the praxis maybe 5 times, maybe more than that. Can you tell the board the last date, roughly, perhaps month and year that you remember taking it?
It was in 2021. Not exactly sure when, maybe, so I know I contacted the board, I think May 2nd, so it had to be around then. I took the new test twice and didn't get 162 because it'd been a while since I'd taken a test. And it was, they claim it is a new test, but I see all the same questions. It's the same test. It's the same test.
Is the May 2021 timeframe when you took that exam, is that the time when you got the 168?
Well, no, 168 was probably closer to 2016 when I graduated. Yes.
At the 168, closer to when you graduated, then you took it after that a few times and didn't reach the 168 mark?
No, I took
Right,
the
that was
new
poorly
test.
stated. You got less than 168.
Yes, correct. Because the new test is 162 and I wasn't making it. And it was, but yes, it was years later.
Okay. So when you took the test initially, it was not a pass. And a number of times, and or has been less than 168. However, because now passing score, your initial test, you want to go back and say, okay, well, I got this then.
Correct. Correct.
And just to clarify, so you've taken it since, like, you said 2016 is when you got, like, the 168. Then the passing score changed from a 170 to a 162.
Correct.
And then you've taken the praxis since the passing score changed to a 162, but you haven't gotten a 162.
Correct.
Okay.
Promise we're not trying to batter. Just a number of questions keep popping up. So I just saw, reduced the passing score to 162. Praxis did back in 2013. So who told you the 168, or at what point was that not accepted? When you went for licensure in Texas or somewhere?
I never even applied in Texas because I moved pretty much to, like, during COVID to South Carolina. Just,
So you had a 168. What stopped you at that point from pursuing licensure?
I mean, well, when I came here, I was just, so this past time I was told that, like, you just look at scores and not like a pass fail doesn't tell you. And I was under the impression, because what I was told, that 168, since the news, if you're just looking at scores, is 162 is the now passing score, that I would get the license. And so I thought that's what was going to happen. That's why I applied. And then I was told differently in the letter.
Had you applied in South Carolina before this time?
In 2021, I applied. Mm-hmm.
I have a question of clarification. So you graduated with your doctorate of audiology in 2016,
Correct.
and then you moved to South Carolina in
2020.
2020. For those 4 years, you were or were not working as an audiologist?
So for 2 years, I was.
Okay.
2018 is kind of when I quit and then did my own business, and because I think I didn't even, and then moved.
Okay. Could you tell me more about the work you did between 2016 and then 2018, and then between 2018 and 2020? When did you move to South Carolina?
2020? Yes.
2020. Okay. If you could explain those two time periods.
Okay, so after I graduated, I worked at a private practice in Dallas, Texas. It was called Hearing Professional Center. I got, hired one day, and essentially they threw me in, and I was pretty much running the practice. The owner, who had been the audiologist for like 35 years, she was just like kind of like near retirement and just was kind of like living life, and she was traveling all over the world, and I pretty much like took over all her patients, and they all loved me. Like, even when I left in like 2018, it was kind of just like a toxic environment. That's why I left. All the patients, like, who used to like love her, saw her for 35 years, they just loved me. They felt connection with me and the empathy. I just did really, really well there. At one point, she wanted me to like sell the practice to me. But like I said, things just didn't work out. It's like very toxic environment. So I do know, I think after I quit at one point, that I did get a letter, like pretty much I think her business just went downhill. I know she begged me back because I guess the patients, missed me so much. But it was just a great experience. Like, I always think about my patients all the time. And then since I couldn't get another audiology job, I just like started my own business. And 2 years later, during that time, I was trying to apply or take the praxis, and apply. And 2 years later, COVID hit. At the time when I moved to Charleston, South Carolina, you couldn't even take the praxis. I remember calling them because at the time I had heard that they were doing online testing. Instead of normally you had to go to a test center. Of course, COVID, everything was down. You couldn't do anything. So I kept calling and calling. Because at one point I found out, speech can do their test online. I was calling them and they're like, nope, we don't have audiology. And I was just like, it's just like delays after delays. And finally, when they did have the test online, so I started taking it, been years, and then that's pretty much around the time when they did change the test to 162. And then 2021 hit, and when I moved to Charleston, I ended up just starting another cleaning business because I was applying for other jobs because I was like, what am I going to do? I can't do audiology, can't get my license, I'm stuck. So I was applying for other jobs. Job market's not great there, so pretty much some of the jobs, once they knew kind of like what I did before, they're like, you're just gonna like start another business, and that's what I did. And in the meantime, like I said, I was studying, taking the test, and then when I knew they lowered the score, that's when in 2021 I started the process to get my license. And then kind of like the reason why I haven't taken the test or tried again, because I just felt defeated. until like, I was just like, you know what, let me call again. Maybe things have changed. So that's what I did in October 2025.
So in the period between 2016 and 2018, you were working as an audiologist.
From 2018 to 2020, I was not.
But 2016 to 2018, you were working as an audiologist in the state of Texas.
Yes.
Does that not require a license in Texas? Did we do a
So-
license search?
Yeah, so at that time, I was still licensed under my student license.
Okay.
And that was all, had all the credentials and had my license through that. And that's what I had.
Okay.
This after you graduate in the state of Texas with a student license.
So I'm not, they gave it to me 2 years, and then like I said, I just quit that job. So I don't know past that.
Was your license, student license, active after you graduated in Texas?
Yes, it was. And they let me
And what-
reapply.
There's requirements different from a fully licensed audiologist. So you said you're self and all that.
Mm-hmm.
So do you feel there was any areas where you opportunity or had to worry about unlicensed practice?
Not that I know of. No.
Revenue?
We had other staff doing other jobs.
Your services, though, were you competent?
I'm not sure exactly what they did, but, I was, yes, testing people.
What did you do?
I did, I was like programming hearing aids, doing testing patients, hearing.
When you were employed for that period, 2016 to 2018, with a student license in Texas, was your job an audiologist? Were you employed as an audiologist and practicing as an audiologist?
I had my doctorate. I don't know if the patients didn't know that I wasn't fully licensed. I had my student license.
But I guess what I'm saying is, like, when they hired you, did they hire you in the capacity of an audiologist to do the job responsibilities of an audiologist, as opposed to, trying to think of another word, Dr. Wiggin, like,
A student with a preceptor, with someone on site that can.
so did they hire you as an audiologist?
And they were fully aware of my situation. So yes, they wanted someone in there who could test patients and who could program hearing aids.
Have a supervisor or any kind of pre?
She was there. Yes, so I followed her.
Traveling the world and she was retired, so.
Yeah. So, she was there, when yes. I would
was
see
on
her,
site with you?
yes.
But during that time, you didn't apply or use that experience and those supervision hours for AAA or ASHA?
No.
Were you working towards your full license in Texas at the time?
Yes, at that time, I was taking the test to get the 170 at the time. So then I could get, instead of, upgrade my license from a student to a full license.
And when you left in 2018, was that because that student license expired after 2 years?
No.
Or could you have continued working in that capacity?
I could have continued working. I didn't like where I was working and wasn't happy.
But then, did you want to go get another job as an audiologist?
If I had my license, yes, I would have.
You work
Yeah,
a credential, your student license? Is
Yes,
that, am I
correct.
understanding that?
correct.
Okay. Did it have an expiration date on the license?
Yes, I know it did, because you had to renew it every year. It was just only a 1-year term.
Oh, so you've been in South Carolina since 20?
Yeah, 2020.
And what would you say you have done?
So I'm on like Facebook, audiology boards. So I know what's going on in, you know, people who have their own practice or things are going on with different manufacturers. I just read up on different technologies. My grandfather has hearing aids. I go to his appointments and see what's going on in the clinics. And like I said, besides just reading, materials on, taking the test and what's going on out there. So, um, if I have to, yes.
One more question to clarify. So between 2018 and 2020, you were still in Texas, and what were you doing then?
At that time, I was working for myself. I started a cleaning business, and I used to be a swim instructor, so that's what I was doing, just making money for myself and just built that business up.
Also, so during your intern, when you had your intern and audiology license in Texas, it requires 1,600 hours. Do you have those hours documented?
Yes.
If you were to move back to Texas, would you be able to meet the requirements of licensure there?
So, and I've talked to several other states. I've talked to Florida, I've talked to Texas, other places. Pretty much it's like the same as here. You need to make a 160, 170 on certain exams. And I know there's even exams, older than mine. And the current one, the current test, or the current passing score now is 162.
Texas, what is Texas?
It's the same. The passing score right now for Texas is 162, same as Florida.
Under the current test.
Correct.
Yeah.
And you would be eligible for licensure there.
No, because the new test, I've taken it like 2 times, and I haven't scored a 162. Only the previous exam, the same exam, but it's a 168. But I would need to take it again.
Apply for licensure in Texas once you graduated and your intern license expired?
No, this is the only state I've ever applied.
And why?
Well, I'm here now. I'm not going to go back to Texas or any other state, so I just applied here.
But when you were working in the private practice as an audiologist between that 2016 and 2018 time, if you had applied for full licensure in Texas, you would not have been granted it because you didn't have the 170. Is that right?
Correct.
Okay.
Because at that time, that test, the new test, or the lower score, 162, wasn't even around.
This is Beth Montgomery, and I move that we go into executive session.
I second. Are you going to stay, Matt?
All in favor, say aye.
Aye.
Opposes, nay. Oppose the same sign. The motion is, thank you. Now we need a motion as to the disposition of this case.
This is Jason Wigan. I would like to move that we do not grant licensure. Passing score has not been obtained on the current practice examination, which has changed significantly in its both administration and weighting of how it scores. This change, done initially back in 2013, but then adopted since, and even significantly so in 2020, 2021, done and to better reflect the current field and clinical responsibilities, considerations, and care that professionals, audiological professionals, audiologists must take into consideration for the betterment of hearing healthcare and public health. A passing of that, of the current test and how it is weighted, recommended before
This is Beth Montgomery, and I second.
Okay, it's been moved and properly seconded that the license be denied based on the information and statements made by the, all in favor, let it be known by saying aye.
Aye.
Opposes nay. The ayes have it and the motion is. Thank you so much for your time, Ms. Schlagenhoff.
Ms. Schlagenhoff, there will be an official written decision issued later. It will probably be 2 or 3 weeks before you'll see that. You're welcome.
Seven, Kelly Caldwell, and she's accompanied by Ms. Crystal, who now ready for presentation. Murphy Holden is her last name for the record. Excellent job of reviewing all the details, so we are very eager to hear closing.
I believe we're just getting the video the PowerPoint presentation up on the screen.
She did assure me that her presentation would take less than 30 minutes.
Hopefully. We'll try to make it brief. Well, thank you all for having us today. The materials before you hopefully make a lot of sense. We operate with the assumption that you all are very familiar with how state laws are written and how bills in the legislature are written, so we will not provide information on the underline and strike-through method that you see in the information, but we will summarize why the changes are being proposed. In general, we wanted to say that work began on the Practice Act within the SCISHA Legislative Affairs Committee around early 2022. Around that time, it was very obvious from discussions with ASHA policy staff members as well as payers, different insurance payers in our state, that there were some areas of confusion about the name of SLP intern in particular. The definition of intern in the dictionary does not match how the Practice Act is using the word intern. So sort of turned into our committee evaluating basically a 50-state comparison plus DC on how they operate. We also added to our project SLP assistant issues along the way, and we did meet with the South Carolina Academy of Audiology in 2022 to at least begin some collaborations to understand with both groups, SCISA and SCAA, what sorts of concerns in the Practice Act each profession may be experiencing with SLP and audiology. That work has gone on to consult with higher education program directors. So we have met by phone or Zoom or in person with various program directors, including Columbia College, University of South Carolina, and several other programs. We've also met with individuals at the Department of Education about various things, including the educator certificate and some of the rationale behind that requirement for passing the praxis. So all of that led to us generating a draft that we sent out for SCISA member comment period in December, and to date have not received any critical comments from SCISA members. That does not mean that there are no areas of criticism, but we wanted to present to the board at least the work we have at this point. The summary here, you all can read, but we basically are adding some technical changes, adding some definitions that match up to federal law on over-the-counter hearing aids, and some other terms. For audiology, we're also trying to streamline and make the language a little easier for perhaps applicants to understand, make it easier for interpretation, and updating the professional title of the SLP intern. So this is the proposal that we've come up with, and we've divided it by different areas. So for the SLP assistant, our biggest factor here was to try to match what we've been hearing from the board in terms of what the board considers to be qualified SLP assistants. One of the pieces of the puzzle is the 100 clinical hours and allowing the proof of the 100 hours to be met with the ASHA CSLPA. Acceptable in the regulations. We pulled that over into the statute, hoping that that would match. And we also added the supervisor agreement on the job training plan for the SLPA, the CEU requirements. The terminology change here for SLP1 and SLP2 went under including a very long Saturday work session that our committee spent together. We've cycled through many terms, and SLP1 is essentially what the SLP intern called. One of the biggest changes here is that the proposal is that the applicant for SLP1 has already passed the praxis. The current SLP intern does not have to submit a passing score until supervised professional employment year. So one of the concerns, of course, is related to employers and the Department of Education, both of whom need to be assured that the person who has completed the supervised professional employment year has the best opportunity to attain licensure at the end of that period of time. We have seen a number of individuals over the past few years who have not passed the praxis and they're obtain that license, and it's really a risk on the employer to hire someone like that if they've and training that person in test-taking skills, test-taking process in order to pass it. The Department of Ed also requires the praxis to be passed to apply for educator certification. So one of the important pieces here was for the SLP1 to increase the requirement to have the praxis passed when they apply. Other increase is to move from 0.8 hours to 10 hours of continuing education. And again, with the SLP2, increasing that continuing education from 16 hours to 20, which matches virtually every other state and matches ASHA's average of. So we've got the strike-throughs so that you can see them. They're printed. Some of these are just very technical pieces to make sure that insurance payers are aware of practice. In this example, this is for an SLP. Definition of intern is proposed to be deleted. Here again, we're actually proposing a new term, not doing away with supervised professional employment. You'll see the new term on another slide. Here is the term we've come up with, which matches ASHA's definition and terminology. It's called a mentored professional employment. So it takes away the word supervision, but it keeps legal requirement for mentorship, which is one of the biggest reasons we would advocate for this change is because insurance payers look at the word supervise and believe that that individual is not able to practice independently at all. That's not actually the case with a current SLP. So those are the definitions that we're looking at. We also proposed adding a definition for supervisor as it relates to SLP assistants who cannot practice independently and making it clear what types of supervision requirements there are. And it also matches ASHA in that the maximum number of individuals that can be supervised is still 3 full-time, but it's based on FTE, full-time equivalents, rather. That's one of the proposals that we've come up with.
May I ask a question real quick?
Yes.
What I understood you to say is that the definitions that you put up here for mentored professional employment and mentor are both aligned with the ASHA definition. Is that right?
That's our understanding.
And then the supervisor definition also aligns with how they've written it?
So that aligns with both the Centers of Medicare and Medicaid Services, CMS, and ASHA.
Okay, thanks.
Oh, I'm sorry. Can you go back? I see you made a change. It says supervisors may be present via telecommunications when providing direct or general supervision. Can you talk more about that, please?
That was ASHA's suggestion when we had conversations with them. It was reviewed with ASHA's State Affairs team, the ASHA.
And just to make sure I'm understanding, a mentor would be someone that would supervise what we might call an intern now or a CF, and a supervisor would be someone that supervises an SLPA who cannot practice independently. Okay.
Yes, so those would be two separate people, and that's why we want to make that clear, really for employers more than anyone else, so that if I'm an SLP licensee, if I'm a supervisor SLP, then I'm supervising an SLP assistant.
And I do appreciate the change to say that, the FTE, because I think that's a good definition right there.
One of the reasons that came up is that we have a few SLP There are some situations where an SLP assistant may only want to work 8 hours, 10 hours a week. Since technically 1 visit out of every 7 has to be supervised, 8 hours a week is pretty reasonable if somebody wants to work very minimal hours as an SLP assistant. So that was where the rationale for FTE came from.
To my knowledge, there is not a definition for FTE anywhere in this document or in our current Practice Act, though, correct?
That's something we may have to look.
Right, well, and that's why I asked, because, for example, for the state of South Carolina, many positions within state government, an FTE is 37 and a half hours per week, but I think probably what you're referring to here for FTE is probably 40 hours a week, although if it's some different amount, that may be something that we need to look at, defining what constitutes FTE.
Yeah, that's a great point. I would consider an FTE 30 hours.
Oh, okay.
Yeah, because as an employer, you have to grant, there's certain things that go along with working 30 hours if you are an employee.
Gotcha.
That also coincides with what the state has for minimum.
Really, to be eligible for benefits, to meet those requirements, you have to be at least 30. Some employers may allow 28, but it's usually 30 to meet that requirement. Now, I will give a personal example. My job is 36 hours a week, so I am 0.9 FTEs, and I just have to be benefit eligible, and that's around 30 to 32 hours.
But yeah, just maybe us, defining when we're using FTE in this, how many hours a week that constitutes. Yeah.
That can be added.
Yeah.
And we have some other definitions that were actually based on CMS language that has been updated over the last decade or two about the use of the terms personal, direct, and general supervision. One of the reasons for this is for employer clarity, not so much that we question anything about what the board understands here, but so that the employers have more clarity, and there's a statute that backs up what types of supervision is required for the SLP assistant. These are the terms that match. This actually came from a proposal in Louisiana that passed into state law in the last couple of years, but these match the FDA definitions for over-the-counter hearing aid, personal sound amplification product, and prescription hearing aid. I will say I am not an audiologist, so we are going to be meeting with SCAA to make sure that they are on with these types of changes. The ASHA staff members did agree that this was necessary. I'll give you a reason why. The cashier at Best Buy who sells an over-the-counter hearing aid might be in violation of our Act the way it's currently worded, because any hearing device is under. So because OTC hearing aid falls under any hearing device, technically a risk that a cashier at CVS or Best Buy might be in violation of our.
Terms don't show up anywhere in our current practice act, so under Section 3, where it says an audiologist may over-the-counter hearing aid, or, you know what I'm saying, with the exception of over-the-counter hearing aid, so that would have to change as well in order to.
Yeah, one of the thoughts is down in the section that's called the limits of applicability. There would be an exception added for the sale of OTC hearing aids, but we've got a definition here so that it references the definition of what they are.
I would recommend, too, that we add a clause, and I can get you the exact language for this because I've seen it in other statutes, after the reference to the 21 CFR, that essentially says, and any amendments there, too, because sometimes we have had courts interpret a statute passed that did not have that clause as the only way it applies is how it was at the time it was passed. And I think you guys probably want it, to evolve.
In perpetuity.
Right,
Yes.
as that may happen. So I can get you that language from some other statutes I've seen.
And then there's a section in the license mandate. ASHA had recommended a change in the second portion of the language here. They wanted to change may to shall. So it says shall only rather than only may practice. And then we added the appropriate level of supervision so that the board can further define that in regulation. Whether or not the board agrees with mandating the ASHA scope of practice and supervision as it's listed here is up to you all. But we tried to make sure that the board had authority to promote promulgate the regulations as needed.
And I would assume on number 1, like that,
That's the same.
okay, that's the
Yeah.
same, got it.
We just separated the two concepts because they're two separate concepts. So just for clarity, we didn't want one paragraph here. We separated it into two separate concepts, and it's clear in the first sentence that that's separate from the supervision requirement.
And that would not affect speech language pathologists or speech language therapists that may be practicing in the schools.
No, because they're in the limits of applicability section.
Okay.
And then this is the language we received from the State Law Enforcement Division about the criminal background check. One of the things to point out here is that it does not require current license holders. So let's say that I wanted to apply for an interstate compact privilege to practice. It wouldn't then force me to undergo this at this point to get a license because I already have a license. So it grandfathers in the people who are already licensed. Let's say that someone graduates from one of our institutions and applies for a license in December. They're going to need to have the extra criminal background check to apply for the license. In addition. So that's what SLED told us we had to put in here, was that going forward, any initial license applicants would have to have the CBC, the criminal background check, but not the current license holders unless they apply for a compact privilege to practice. I hope I explained that clearly. That's what we understand from SLED. And then these are just the technical changes that I went over earlier about the different license levels. So we described SLP2, which is that person who's already finished that mentored professional employment year. You can see their requirements are basically the same as the current Practice Act, but it's just organized differently. And then it also allows for the ASHA qualification. Recall that reciprocity is in a different section of the Act. SLP1, so it just references that they have to have B1 and 2, not 3, which is that completion of the mentored professional employment. So we tried to simplify that requirement. That's 1 and 2. Under SLP assistant, instead of the single section about the bachelor's degree, we broke it into 3 parts, and you'll see that under the bachelor's degree, it allows the exception for another name of a bachelor's degree. So it says a bachelor's degree from a regionally accredited institution in speech language pathology, or a bachelor's degree from a regionally or nationally accredited institution, and proof of completion of the minimum required coursework. So we tried to reference what is already in regulation, which is subject to the board's interpretation. And this is a piece that is important for payers. I'll give an example of TRICARE as a payer. They currently believe that clinical fellow SLPs, or what South Carolina calls SLP interns, are not SLPs. It's very confusing as to why they believe that, but we wanted to add clarity here that they use this title of speech language pathologist, or SLP. I know that the audiology group had mentioned they want to have professional privilege to use the title Doctor of Audiology, so that's written in here as well. And it's clear assistant licensee should use SLP assistant or SLPA. So we wanted some clarity in terms of what the person calls themselves. Here's the reciprocity section. It's just a little technical switch. It's 2 requirements and including an SLP assistant license. So there might be reciprocity if that's appropriate. Yes.
They stayed away from the word reciprocity because of the broad implications by endorsement. If their requirements are similar or the same or equivalent to ours, then they can be endorsed. If they saying for years, there's no reciprocity. Applications of the word reciprocity or
Or I've always thought of
endorsement?
them, yeah, I've always thought of the words licensure by endorsement and reciprocity as being the same.
The same?
Avoid that, because the statute still makes it clear that the board has to make a determination about whether that other state's licensing requirements are substantially equivalent or not. So to me, it doesn't particularly matter whether you call it an endorsement or a reciprocity, because you're still doing the same evaluation, but.
We didn't actually change the subject of 40-67-250. It said the person holding current license in another state. So we didn't go there. It's just a title on the slide so people understand that we're talking about reciprocity.
I was under the understanding that reciprocity would be an agreement between two states to accept one or the other's,
Oh, like a formal agreement.
yes.
Well, and so I will say some boards do have formal agreements with other states where sort of the board has, a great example is North Carolina and Georgia, right? We know we might have a lot of people crossing from North Carolina into South Carolina and vice versa, or Georgia to South Carolina and vice versa. So many boards have essentially a reciprocity agreement where they've already evaluated whether it's substantially similar or not, and said, we're going to deem this level of license from North Carolina to be this in South Carolina, and this one from South Carolina will be treated like this in North Carolina. So that makes sense, that maybe that's why they avoided it, is because we don't have to formally enter into those agreements with any other state.
I think a compact would be something similar to reciprocity.
Yeah.
Once it's,
Once it's up and fully running,
yes.
and yeah, I would agree with that.
That would, but that's a third party and they charge for members. Where honestly, if states, well, I shouldn't say that. Yeah, and that has to be outlined for board administration to make that decision. Otherwise, we're gonna have all these people come before the board to judge whether or not, to state whether or not that it's equivalent.
So this, other than the parts that are underlined, this is already law in
Right.
South Carolina. I don't know how many maybe substantially similar type cases you've had come before you in the past, but this, except for those, the underlying parts, is already the law.
So this one here would allow, like if you had an SLP assistant in North Carolina that was licensed by the state of North Carolina.
If the requirements are substantially similar.
So that might,
If, in another state, if the requirements for licensure in that state are at least the substantial equivalent to the requirements provided for in this chapter. So it'd have to be, I'll give you an example. Georgia has a sheet you can download that's called Georgia Approved States for Licensure in Georgia by Endorsement, and you can search. State is on the list. You can apply for a license as long as you have the.
Yeah, I want that list.
Case was the lady from Arkansas that had been.
I was thinking of the one from Texas.
And the one from Texas and one from California. We did not endorse. Not.
There are quite a few states that have significant differences from us. Not our job to necessarily tell you all what you want to change. We just wanted to match the board's signal so far as SLPA qualifications.
Well, because I'm wondering if, like, so with this right here, the biggest thing that's SLP assistant in there when you're looking at reciprocity. I'm curious, because we've seen so many SLPAs that have come before the board to look at licensure, right now, this, so it would say substantial equivalent to the.
South Carolina, yeah.
We have to compare.
But I mean, is that gray? Like, if they'd had 80 hours of observation, or they. I don't know, that's just kind of what I'm thinking. We already have so much discussion and so much difficulty by.
I think perhaps,
Possibly.
if I could maybe add to this, if this gives the board authority to generate a list of states that you will accept an SLP assistant, that authority, perhaps, I would say it's probably not going to be frequently used.
But then if we generate a list and that goes in this, I mean, it's super hard to open up with the list you've done, and what if those states change? Really hesitant to do that. What was the reasoning by adding the SLP assistant to this language in 46?
That was ASHA staff's suggestion. They said that they wanted to see more licensure by other states for SLP assistants, given the national certifying S.
The example that you just provided, if it was 80 hours of observation, not equivalent, and that's not direct, direct service. So
What if it was
None of
80
that would
hours?
count.
What if that was 80 hours of direct and we say 100? Is that pretty close? So then are we bending to 80? And then what if somebody says,
if
like,
we,
hey, I got 70, will that count?
we have 100, so it'd have to be that.
It'd have to meet that.
The assumption and only had 70 hours or 80 hours, they would have to submit a plan under that 4-month period to complete, to bring them up to that 100 hours.
But, I mean, I see what you're saying, but what I'm thinking is if this were approved, and maybe I'm reading it wrong, but if I'm an SLP assistant in Texas and I had 80 hours of direct, whatever, and I'm coming here and I'm saying that's a substantial equivalent, 80 is pretty close to 100, you should grant.
100 to 100. So 100 is what South Carolina has. Sufficient of 20 hours and
So then
wouldn't be
what's
eligible.
why include that there? Like, what's the important piece about SLP assistant with substantial equivalent? I think that's where substantial equivalent, is that equal to exactly the standard? Because to me, it's not. To me, substantial equivalent means, hey, I got some wiggle room. It
Right.
doesn't have to be exact.
So that phrase is in current law. One of the potential solutions here would be to change meeting the minimum requirements for licensure. So you set a bar, so we could change that word substantial and requirements.
But then if they're meeting requirements, it's not. And that's just what I'm thinking. I'm sure there's something else I'm not thinking about, but just right off the bat, that's what I'm wondering.
To me, 100, the minimum would be 100.
Yeah, it seems like if it's not broken, for lack of a better word, then why are we trying to add that in?
I think this is where we had to make a few compromises on what lots of parties wanted to see. So we can certainly consider taking that back out if it doesn't make sense to have an endorsement.
Already allowed for the SLP A from ASHA. That's already been already allowed for like the registrant. I don't know, I just, the part that kind of gives me a little bit of heartburn here is that that this language, although it's always said substantial equivalent, we're now including SLP assistance to that, and there's a lot of variability about SLP assistance programs around the nation. They could have been practicing for a long time in other states.
Yeah, and those standards do change from time to time in other states. So what somebody did, say 20 years ago in Tennessee may not be the same thing somebody did 10 years ago in Tennessee.
So they could,
Some states only certify them or register them. Some states they're called paraprofessional.
so to me, if we keep what we have about SLP assistance, we have lots of different pathways to get there. But if this were to pass, now we've sort of got another pathway that's kind of gray. I mean, that's just my takeaway.
Absolutely.
Because like I said, substantial equivalent, like, if we have 100 hours and maybe somebody comes before us and says, I have 90. And then somebody else sees, well, y'all passed the 90 and I have 85. Right. So, I don't know.
It could leave some wiggle room for the board to decide if, that person meets definition for substantial equivalent. So
I mean, I definitely see
Yeah.
what you're saying. It may allow more people in, more people to meet, to get granted the license. I don't know, how do you feel about it, Mac? Because you're the one that kind of reviews those applications.
What if only substantial was removed and it would have?
Then why would you even have that language? If it is the equivalent, then what's the reciprocity? They're meeting the equivalent, they're meeting the guidelines.
Well, again, when I think of reciprocity, I think of an agreement between two states.
Formal agreement.
A formal agreement. So would this be reciprocity? We already accept, the ASHA certification for the 100 hours. I don't know, would this give the board wiggle room to say, well, maybe if the person got the ASHA certification, but maybe didn't have a bachelor's degree? I don't know.
They have a
Four
two-year degree.
pathways under the ASHA SLPA. There's 4.
I always like to put a face to who I'm thinking about, like who might apply for this type of situation. Maybe they've worked as an SLP assistant in, super familiar with their assistant qualifications, but maybe they've worked in Tennessee for 10 years. They've completed their bachelor's degree many years ago. If they apply as a new applicant, are we wiping out that experience, and do we have to consider continuing ed? Well, licensure by endorsement, then you're recognizing that previous 10 years of experience when they come across. That was kind of what I'm envisioning with this endorsement type of scenario. Elsewhere.
I think now, like, given your example, like, they've been practicing in Tennessee for 10 years, maybe they had a 2-year degree, maybe they had 50 hours. If they applied here, we would say no, because they.
But each case could be considered case by case, and this gives a little wiggle.
And I guess that's a.
Get their 100 hours.
But they still wouldn't have a bachelor's. I mean, in that particular situation, I don't.
So if this technical change causes too much angst, it can come out since the SLP assistants have other pathways. But that was just a very strong suggestion from ASHA's State Affairs team.
Because they felt like, as a state, we weren't licensing enough, or we were too stringent on the SLP.
They didn't have any criticism of the degree requirements or anything like that. They just said, hey, why don't you include them in the endorsement section, the reciprocity section. It was just a
Sure they did
proposal.
that.
And we did in some other sections make sure that speech-language pathology assistant was always listed separately and not in a list of audiologists, speech-language pathologist, and assistants. They're not connected that way anymore.
Yeah. This is the CE section. Again, it just technically increases the requirements. I'll give an example, and the reason I had mentioned Georgia earlier, at the bottom of their license by endorsement handout, dated 1/7/2019, so after the last major update to the Practice Act for Speech and Audiology here, they reviewed our Practice Act and still decided that they would not recognize our licensees for licensure by endorsement in Georgia. So at the present time, I'll use myself as an example. I actually do see some patients from Georgia in my practice in Anderson, Carolina, but they come across state lines, so they are in South Carolina receiving services. And I am not currently licensed in Georgia because I'm not required to be licensed, although the patients are residents in that state. That being said, if I wanted a license in Georgia, if I did not have current ASHA CCC SLP, I would not be eligible for a license in Georgia as an SLP. So we have reached out to the Georgia Board of Examiners to ask if increasing the CEU requirement would meet the standards that they found deficient. To date, we have not received a response, but I have reached out to a colleague who serve on the Georgia Licensing Board to see if we can get a little more of an answer from them. This also matches most other states that require an average of 10 hours per year.
Just so you know, and you guys may already be aware of this, downtown with the legislature, there is generally some pretty strong opposition to increasing continuing education requirements unless there's really good reasons for doing so. So perhaps putting together a chart of, well, these are the states that require at least this much CE that we're proposing here, and being able to tell them things. For example, if you get word back from Georgia that, yeah, the only thing that's blocking that, essentially that endorsement in Georgia is that our CE requirement is lower, those would help explain part of that recommendation to the General Assembly.
We are definitely working on that. It's on my to-do list to make that spreadsheet of the state. On a cursory review, we looked at most of the states in the Southeast, and they do require 10 hours. Spreadsheet for that.
And I mean, I hold my ASHA Cs and my license in South Carolina. I am always, because of ASHA, I feel like I'm always getting over the 10.
Well, and that's probably a good thing to tell them too.
Whether other people are doing that or not, I would assume that they are, but.
Too many ACE awards to count, so I have lots of
And it's
continuing
important-
ed.
It's important to be in sync with your border states, so that
Yes.
they'll hear that. Georgia, North Carolina, Florida.
License, once the compact is in effect, you can just,
So I technically could maybe apply for a Georgia state. There's a few avenues. And then here is just a technical change of SLP1 and SLP2. That's really all this is, and then change out of supervision to mentored professional. The activate, the inactive license, we reflected the same CE increase, continuing ed increase here. So it reflects the same. And in this section, we had lots of meetings. I lost count of how many meetings we have discussed this section of limits of applicability. One of the concerns we have that resulted in the language in number 5 here is that there are individuals in our state serving BabyNet clients that are technically family trainers or service coordinators who are providing services that align with the SLP scope of practice. And so we wanted to be clear that the person who has a license, whose practice overlaps, et cetera, where it says including providing any services aligning with the scope of practice. So it references the definition, so they cannot provide those services under their license. Another piece of the puzzle here is in number 6. We believe back in 2018-ish, when that Practice Act change went through, there may have been some tweaks during the time that the bill was in the legislature. And the confusion in number 6, if you read this very black and white, an educator certified by the State Board of Ed does not have to have a license. Any educator. So that could be a first grade teacher. That could be a 5th grade teacher. That could be a music teacher, the way that number 6 is currently worded. So we recommended improving the language to be more clear that this is referencing an individual certified by the State Board of Ed as a speech language therapist, so that we're not allowing a first grade teacher to call themselves essentially an SLP under their educator license.
Not currently happening. Maybe, we don't know.
Well, what we hear are not always substantiated with written reports, but anecdotally, we have situations where someone is providing articulation treatment or articulation licensed. So they are currently not licensed or certified by any regulatory body. They receive a credential to practice under SCDHHS and DDSN as a family. But like music educators, they are certified under the State Board of Education. So they would fall under number 6. So we're hoping the improvement in number 5 and 6 gives a little more teeth to stopping some of this unqualified practice that's. I would say the BabyNet field is probably the biggest situation where SLPs have been concerned about encroachment, the lack of referrals. They go in, and a case I heard recently, a child was supposedly receiving feeding therapy, was found to be eating playground mulch because the family trainer was doing all kinds of mouth play with the child, and so the child developed pica, essentially, and there was no SLP involved in this EI case because the family trainer was doing all of the services. Give this more teeth to help make sure that the public.
Original intent behind number 6 was for grandfathering the speech-language therapy would not be eligible for licensing, and was the full intent. The secondary intent was for anyone who, of course, they were all certified as speech-language therapists, but anyone who was eligible for licensure would apply for LLR license, and then only would be those who could not meet qualifications for LLR.
To date, we believe there's around 70 to 75 SLTs that are certified by the Department of Ed that are grandfathered in. Some of them actually, we have heard, have their ASHA Cs, which is very interesting. Some of them.
And I think some of them may have gotten their master's degree and everything. They just didn't continue their Cs.
Needed at the time.
Right, and so they've just let it lapse, and now it would be too hard to get a license or to get their Cs.
In some cases, the praxis scores are only available for up to 10 years after you take the test, so they may not be able to submit proof of passing.
Or did not pass before, and that was.
It was not required to pass before. That's kind of the sum here, and you can see number 7, that's where we put that limit of applicability here, that the selling of over-the-counter hearing aids is not something that requires a license to practice. So it references back to that definition we mentioned earlier, so our lovely clerks at Best Buy and CVS don't have to have a license to sell an OTC hearing aid.
So with the change to speech pathology 1 and 2, like, would you see people including that in their title, like I'm a speech-language pathologist 2? Or they would just continue to say speech-language pathologist, but if somebody asked for their license would physically say 2?
I think the license would say SLP1 or SLP2, but they can use the professional title, which is why we added that in the titling section for a speech-language pathologist, because that's what the federal.
Then if this was approved and all this went into effect, what would then be sort of that marriage or communication with Department of Ed and changing their terminology? Would they just?
Right now, when we worked with the Office of Educator Certification last November, gave them the intention that we were going to be improving some language, so they went with language that basically referenced having a license from this board.
That can still stay.
And I just there's a question of clarification. So you cannot get your educator certificate if you had not passed the praxis?
Correct.
That's correct. Okay.
Cannot get it. And then they just reinforced that with the new reg update last year.
You're applying now.
You're applying now, yeah. Okay.
And that's one of the reasons that is done is there's another aspect of state law. It's in Title 59, I think sure, but there's another section of state law that requires the praxis examination for all educators. certified under the Office of Educator certification, they have to adhere to that same state law. So basically, the way it was explained to me by Ms. Hipp's office was, we're issuing a certificate, we have to adhere to Title 59.
And so do you see that changing, like the SLP 1 and SLP 2, both of those require the passing of the praxis? And like you talked about right now, the intern license, you don't have to have passed the praxis to be issued that license. You can pass it within that year period. So do you see that change? How do you see that change playing out if it were passed? Like as far as like graduate programs, people coming in from other states, that type of thing?
Murphy Holden has lots of ideas on that one.
Yeah, well, number one, a lot of the rationale behind this was for consumer protection, for one thing, for employers. So an employer knew when they were hiring, because whether you've passed the praxis isn't part of questioning. I mean, I guess you can ask that, but as long as the person has the intern license, then they are eligible for employment. But what has happened in many cases is that you have someone who is struggling passing the praxis and may not pass the praxis, and you've hired someone on the basis of being an SLP, and then they're not able to do that if they can't pass the praxis. This does provide that protection. And it also is in line with the title protection as well of using speech-language pathologist, because all of those requirements have been met. The only thing is that 9-month period of mentored work experience.
And another example would be an employer that maybe they provide outpatient services. They've gone through 3 to 6 months of training an employee, credentialing the employee with insurance, and then 3 or 4 months later, 5 months later, that person then no longer is eligible for their SLP intern license because they haven't done the last piece of the puzzle, which is pass the test. So it helps provide protection for employers that are willing to spend the time, money, and have a mentor for the SLP 1, so that this individual is trained and they remain eligible to stay hired. At present, employers are taking a risk in hiring this initial license holder, the SLP1, if we get the term. And that risk turns into, well, we don't want to hire those people because we don't know if we can keep them on after a year.
I appreciate that. And then I appreciate all the work that has gone into this. I would hate for you guys to do all of this work if there is talk at ASHA is ASHA reconsidering what a CF mentorship program looks like?
Don't know.
Adjacent to that would be OT, PT that does not require this 9 months. And so that just has me thinking, as a past employer, like,
One of the things that happened this past summer related to CMS was CMS put out some guidance that was confusing about whether or not this SLP clinical fellow was considered an SLP. In our state, because they have a license, that's not a problem, but in other states, that is a problem. Or if the license is called temporary or provisional, that's a problem. So when I was talking with the ASHA staff about this subject of the clinical fellow, like, would this fellowship year go away at some point? The resounding answer was no. One of the reasons for that has to do with the direction that the board of ASHA has basically put into play. Another reason for that was given to me was related to clinical training. The clinical services part of ASHA's staff also feels that this needs to stay in place. The other piece is that federally CMS requires the completion of this mentored professional employment year. And even though they just did a regulatory technical change that got published earlier this month, I think it came out in November, that basically amended some of that problem from CMS in July. That technical regulation change is probably not going to happen for another decade or longer. So even if the clinical fellowship was to change substantially, I don't see this affecting at least a decade.
That's the final stopgap measure, that 9.
One of the other concerns that seems to come up in conversations in social spaces with SLPs is, why is it that when an SLP graduates, they're not fit to practice right away? As far as not requiring mentorship, not requiring supervision. Why can we just, not finish our program? Essentially, some of them are talking about, we should get a clinical doctorate. And I've had conversations mostly with the policy team about this because, let's say, theoretically, if we went to a doctorate for speech, like a SLPD, kind of like the audiologists have, one of the concerns is, would reimbursement for services match that? And the resounding answer is also no. There is no way that the reevaluation of the codes, the RVUs, the work time files that are done at the level of the AMA and CMS, there's no way that that's going to come up. The RVUs have not come up in many, many years for our services, even from the move from bachelor's to master's. So I don't think it's smart from a financial and business perspective to see our practice move up to a clinical doctorate across the board.
That's only 30 years.
It's still up in the air with curriculum and the very. I have a question about fourth step there. You want to talk a little bit about that?
Oh, so essentially what we're trying to do is engaging with stakeholders. Ready, Set, Go is when we kind of finalize all of the language and make sure that everyone's in alignment together. The fourth step is to seek a legislative sponsor. I am personally the one putting the brakes on the process because I don't think it's smart to take a bill that's not ready to any legislative entity and say, hey, we want to do this. So to date, there's not been a legislator who has seen this information or panic. Another reason is we need to finish collaborating with the South Carolina Academy of Audiology about language that they may want to see. The slide encompass some of the ideas that we came up with for audiology, and some of those changes I really would like to see what SCAA would like, but just generally speaking, they wanted to add some clarification and scope of practice that services like intraoperative monitoring, performing cerumen removal are included. After lots of discussions with ASHA staff about that particular piece of the puzzle about cerumen removal, we know that there's a risk that we bring the otolaryngologist to the table to debate our Practice Act bill if we bring that up. So our amendment there, we're hoping SCAA is okay with, but it says performing cerumen removal immediately prior to audiologic assessment and treatment. So it's tied, but that's just our notion. I'm not sure what SCAA will like to see there. So we'll have to see what. Out of my ears. So. Right.
Our response is we'll accept it as information, and at some point we will put it on the agenda. Keep us informed if you have a date about moving forward with a legislative sponsor. Please keep us informed. 8 is resolution guidelines, and that's continued business. We started this discussion at the last meeting, and we want to continue with that.
Madam Chairwoman, based on the feedback that I got from the board last time, I did kind of work back through the guidelines to set out separate separate guideline penalties essentially for interns. The question did come up from Mac about should we treat perhaps interns and SLP assistants similarly within these guidelines? And that, to me, does sound like a good idea, or if we need to treat interns and assistants even separately from each other, it's not that difficult, to break out a category for them. I did try to draft it kind of in two different ways. Initially, the version that we had, as you know, sort of wrote it all out with words. And so if you look at page 3 of the current draft, that's sort of the written all out in words version. But when I was working on it, it sort of, to me, I thought, this kind of lends itself to being prettier maybe in a chart or easier to follow in a chart. And so that's why I sort of created the chart version that you see in here. Certainly we could keep both. We could do just one or over the other, depending on what the desire of this board is. I did also try to highlight specifically the concept of, based on the timeframes, is a consent agreement essentially initiated by staff, is that acceptable or not? And anywhere it said a board appearance would be required, I said no, that staff cannot initiate the consent agreement because the board appearance is required. Beyond that, where I kind of set the fine amounts, I was just kind of guessing. Those are obviously easily changed. So if I suggested a fine amount of $100 in a place, but we're thinking, $50 is more appropriate, or no fine at that level or whatnot. And same thing as far as the ethics course. So for example, if we're feeling like an intern maybe doesn't need 3 hours of ethics coursework, as CE, then, that's easily modified to either take it out completely if we don't think that that's needed at all, or to reduce the number of hours and whatnot. And I did also, and I felt like this was a really important part, I did add a sentence that for the sections where board appearance is required, that these guidelines are basically just benchmarks, general ideas of where you think you're likely to land, but that you always maintain complete discretion to deviate in any particular case, because obviously the facts of any individual case are going to be different. And so even though, a guideline range might say, well, the fine starts at $750, there may be testimony presented to y'all where you say, we don't think a fine is appropriate in this one. We just want them to do the continuing education. So I wanted to make that really clear in here. So the only stuff that would really kind of be set in stone would be staff offering the consent agreements. Their parts would be set in stone. But anything coming before this board, you'd still remain complete authority to shift however you deem appropriate as a board on sanctions.
Can you get it down to 3 pages instead of 6?
Yeah, if y'all prefer like
The chart
the
is
chart
good, looks good.
version over the written out version, it's so much longer because you have both in there right now. So if there's a type that y'all prefer one over the other, I can definitely take out the other and not have both. I just left them both in there for now because I didn't want to have to recreate it again.
Well, and some
Okay.
people visually may like the written out, some people.
Right.
Okay, so I have a couple questions.
Yes,
Can I ask?
yes.
Okay, so in no particular order, regards to the SLPAs, I know they're not on this chart yet. But my question was, so we're looking at renewals. Mine is more of like a sort of a procedural question. Let's say I'm an SLPA, my license period ends March 31, but I'm no longer I'm no longer working. And so I no longer have a supervisor. So I'm not going to renew, can I renew that? And I think the answer is no, because
Right.
so I'm wondering how that sort of plays out with regards to renewals, specifically for SLPAs, because it's contingent upon them.
Right, so it's a failure to renew with continued practice during that non-renewal period. Like the title at the top just says failure to renew / continued practice, but I can sort of set that out, because that's what we're talking about, is we're talking about the period where the person's license has not been renewed, and that until they either do renew or try to renew, and they have engaged in continued practice during that time. So I can clarify that.
Okay.
Because,
So I have a
Right.
question. So what's the difference between, just say an assistant has a license, and for whatever reason, the supervisor, and then the assistant, decided to go their separate ways, but the license is still current, but at this point, the license is going to be made inactive because the person doesn't have a supervisor. So that means, the license is still in an active status, but it's inactive because it's contingent on them having a supervisor to practice.
So when it comes up for renewal, my guess is if I'm an SLPA, but I'm no longer currently working for whatever reason, I can't renew it.
Well, you could renew it. You can't practice until your supervisor.
So, because I was always under the impression that an SLPA could only get a license if they had a supervisor. So I wasn't sure how that worked with renewals if you don't have a
They can
supervisor.
only get a license if they have a supervisor, but as far as renewing the license, status until they provide the proper supervision paperwork and is it.
So, like if I'm an SLPA and my license expires at the end of March, but I'm not working, do I have to renew that? So then when I go, then let's say 6 months down the road, let's say come October, I do want to work, I wouldn't fall under this for not renewing on time because I didn't have a supervisor. I just feel like I'm just curious how all that will play out because they have to have a supervisor to get that license. And I wasn't sure if if they're planning on working again, if they would renew but be inactive.
If they continue to practice after they're renewed and they don't have
Sure.
a supervisor, then that's where the issue comes in.
Right. But they wouldn't fall under, so like the second part of this chart is just failure to renew. Failure to renew, I guess, but with the caveat of continued practice, and that wouldn't be them. Versus if
right, unless they are in fact practicing inappropriately, which would also essentially constitute practicing without a supervisor. So I don't view us as treating it under this. I view us as sending that through the normal investigative process and through it to ODC, because then you're going to have multiple violations going on.
And so then that's kind of another question I have, just big picture wise, the sanction guide. Like, what's the difference on page 1 for unlicensed, the chart for unlicensed practice versus page 4, failure to renew continued practice?
So for an unlicensed practice case, that's somebody who has never held a license here. So it's people who have had licenses and failed to renew but continued practicing anyway. And that's what we're going to see most often, I think.
So then on the first part, somebody who's never had a license, like how, I guess I don't understand why it's deviated intern and all other applicants if they've never had a license.
Because of what they would be applying for. Because we're not necessarily going to know about it until they apply.
Okay. So then, like on page 4, that's your typical person. What comes up, they forget to renew,
Yes.
but maybe they've worked.
Yes.
And if they forget to renew, but they haven't worked,
Right, so they could do their application for renewal for, what is it, 60 days after? I can't remember.
30 days after the actual.
After it closes. And then once we're past that 30 days, they have to fully reapply, like they're brand new under whatever the standards are at the time they're making that application.
I'm not saying I'm not practicing.
Right,
Day, then that's cool.
right.
I did practice.
Then we have this stuff happen.
okay, that makes. I guess that I was thinking the failure to renew continued practice was the same as unlicensed.
I mean, they're similar. We're distinguishing them between those who have already been licensed in South Carolina
Right.
and did just kind of forget to renew, or didn't, maybe they didn't forget, maybe they just didn't do it.
Right.
Or maybe didn't have their CE hours done, didn't have the money to pay the fee, or, whatever the situation is, just didn't take the time, maybe, versus, somebody who has never, ever been licensed here.
So then, like, looking at page 1 again, where the intern first can offend, third offense, trying to think of somebody who, because an intern license is typically granted for a year. They can renew once. So I was just trying to think of an example of when they would have a third offense. As an intern? Or maybe, because at that point.
Oh, I think,
That would be like year 1, I guess.
I think in my head, I kept that in with the thought that perhaps the person was an SLP assistant at some point, and then now they're an intern, and so you might have an odd situation like that. I think it's not likely to happen often. But, and you'll see if you go to page 4 that I actually put a comment for intern second offense, that there could not possibly be a third offense for interns, because they only do get to renew the one time. You know what I mean? So if we had somebody who had this, say, once before as they were an intern, or even maybe twice before as an intern, the next time they're applying with us, they should be applying as an SLP.
Right. Yeah.
And so
then-
we'd jump over to the SLP chart and we'd be looking at, well, SLP third.
Yes, okay. And then same thing for like on page 3, Roman numeral 2, unlicensed practice, applicants for initial licensure other than interns. And so I was thinking, okay, what type of license would that be?
But I think that becomes the question. Do we want to capture all the SLPAs here? Or just SLPs and audiologists? Or do we want to keep the interns and the SLPAs together?
Thinking that interns, separate category, because they were new to the profession and maybe didn't know.
Right, yeah. That was the impression I got from the comments from last time.
Yeah.
And I just didn't know if y'all felt the same way about SLPAs, but that was a question that Mr. Williams brought up. And so I didn't know the board's feeling on SLPA and whether we should kind of put them with interns, kind of have their own little category, or keep them with the all other license types.
For SLPAs are completely different from both.
So they probably do need their
They
own,
can never practice independently.
Right.
SLPAs, so they should be in a different category perhaps.
They can do it their whole life.
Right?
Yeah.
I mean, they come in with 20 years of. Their program in their August meeting, that's.
So out, and I can also add a footnote in here that essentially says for the failure to renew with continued practice during that time for them, that if it's a failure to renew with continued practice while they also don't have a supervisor, that that's something that cannot be treated under this chart, that it does have to go through the normal investigative process and ODC process.
Just trying to think of a scenario too of like when an SLPA wouldn't renew, because your supervisor should be renewing at the same time and that should be linked together and you have to report. I mean, I would find that, I think it would happen and I'm sure there's scenarios I'm not thinking.
Thinking, have you seen circumstances like that come up? Like if I'm an SLPA and I'm not currently working, the renewal period comes up, I don't renew, and then I do start work, I just would reapply? And then, but on the other hand, I could have renewed, but just not been able to work until I submitted the paperwork about my supervisor. So they can kind of do both things.
It would be inactive.
That seems more confusing to me, to renew and be inactive. I feel like I have done renewals with SLPAs that have come to work, but have had supervisors in the past. But they were under the impression, I guess I was under the impression too, they did not have a license. So that was the protocol we always followed. Unless like there's times where maybe a supervisor went on maternity leave, but then we wrote the board and then we filled out the form. Within, I think it's 7 days. I don't remember the exact time, but.
So I will say from a practical perspective, the smartest way to think about it when you have an inactive license is that you do not have a license, because you cannot practice when you have an inactive license.
That's why I think it'd be more confusing as a SLPA to renew.
Right.
In my mind, that doesn't make
And
sense.
we don't get a whole lot of those
Yeah.
in that situation, but
A lot of work too, so thank you for doing this.
You're welcome. Well, and I would like to apologize to Ms. Montgomery and Ms. Emery. I got very bogged down with some other stuff with other boards, and so I kind of dropped this in their lap on Monday and was like, here's the draft, get me feedback. So they've been very gracious about that.
I hadn't heard from you, I was a little concerned.
So it will, we are back up to full staffing and advice council, so things should even out again with the workload. Let's put it that way.
But the respondent doesn't have to accept this, so they can still come.
Correct.
Yeah, okay.
Correct, yeah.
And then
so-
after that, all bets are off.
Right, it would go to ODC, and ODC would do their thing. Yep, yep.
So can we have another final draft at that April meeting?
Yes, ma'am.
Okay.
Yes.
Thank you.
And what I understood is that it sounds like maybe most of you prefer the chart version? Yeah?
I like both.
Okay.
I know that's. And so just to clarify, if I'm an SLPA and I know we already talked about this, I must just make sure I'm right. I fail to renew, but I didn't practice, then I just, if I'm in that 30-day period, I just apply for renewal and.
Yes, and that would be true for anybody, right? So anybody who they let their license expire, but they did not engage in any practice during the period in which it was expired, then none of this is going to impact them. Because the concern is practicing when your license is expired and when therefore you are not lawfully allowed to practice.
Right, okay.
Yeah. So I think we explicitly asked that question on the application, don't we? The renewal application? I think we do. Or maybe staff just asks them I don't know. But I think we ask.
I don't know if we have any on that renewal application.
Yeah, we'll look and see before the next meeting, but for some reason, I was thinking that we explicitly asked the question. So,
And then do you guys feel like, so the first offense is between 1 and 120 days?
for the unlicensed practice,
Unlicensed practice.
right? Yeah, I know y'all had asked for the failure to renew with continued practice to break that into categories of 1 to 30 days, then 30 to 90, and then 91 or more. But I wasn't asked to sort of do breakouts smaller than that for just the straight up unlicensed practice. We certainly can do that if there's a desire for that.
I mean, I don't know. I'm trying to decide how I feel about it. Like if again, I'm thinking of the people that we've seen got to renew and it's April 15th, and I'm penalized.
There's no grace period allowed, correct? Like that, and that's because
Right.
of our statute, not because of our regulation, correct?
Right. Once your license expires, it expires and you cannot practice.
Period.
Right.
That's because of chapter 67.
Yes.
Okay.
And that's true of all of the practice acts, for all the professions that we deal with here at LLR, is that once that license expires, you cannot lawfully practice until you go through whatever process is set up for that particular license to either get reinstated or get fully relicensed or whatnot. And it's true for lawyers, too.
Great, great. All right, well, thank you very much.
Thank you.
You're welcome. And y'all should see updates based on this feedback much sooner than you got this time.
Okay. Next item on the agenda is 20 Board of Directors request for travel approval. Mr. Williams?
Yeah, I just put this on the agenda, so I'm pretty sure that NCSB is probably gearing up to prepare for their, this year's meeting. So talk about approving travel for our board members for NCSB.
Denver, Colorado. And you are exactly right. It's, the board planning meeting is scheduled to begin on March 6th. So travel would probably be between March 5th, so we can get out there, and March 8th to come home. All just kind of looking ahead, the conference. The spring one, but just to kind of have on record, those are the two.
I motion to approve the travel of our national board members to Denver, Colorado in March and October.
March.
Just March. Okay. I'm slashing October for now.
A second?
Second, this moving properly second, that the board approve. All in favor, let it be known by saying aye.
Aye.
Aye, opposes nay. Ayes have it. There's a big bear outside. Thank you so much.
Thank you.
Be winning.
And Beth, Dr. Wiggin, if you can give me that agenda as soon as possible for that, because I'm going to need that to prepare your travel request.
The agenda is not out yet. I don't think she said, but I know she's working on it.
Even the
Yeah.
tentative agenda work.
Okay. She hasn't sent that to us. Yeah, for the board planning meeting.
So we'll send that to you as soon as we
Yeah.
have it.
So I know Katie's working on it, so we can ask her.
Item number 10 is 2026 election of board officers. The floor is now open for nominations for.
I would like to nominate Dr. Gwendolyn Wilson for our chair and Beth Montgomery for vice chair of this board.
Second.
I would like to motion.
Motion, okay. So it's been moved.
And seconded.
Aye.
Next item then is the ASLP compact update.
Oh, there has been no update since the update pass, or after the NCSB meeting. There's been no meeting, there is no update at all since the release of that Compact Connect and everything that they displayed reported on back in October.
So she can hear you.
I-
You got it.
I got it, yes, thank you.
So the next meeting will probably be, we don't know when, they'll let you know.
Beth Montgomery, and I motion to adjourn.
Second.
Second that this, all in favor, let it be known by saying.
Aye.
Name use the same sign. The ayes have it. Thank you all very much for your attendance and participation, contribution today.